Hello everyone, this is Apurva Pandita and welcome to Livelaw. The Supreme Court today, that is on 4th of August, has granted a stay on the conviction of Rahul Gandhi, a Congress leader and former member of parliament, in a criminal defamation case related to his comment about the Modi surname. This stay also means that his disqualification as an MP is now on hold. The court highlighted that the punishment for this particular offence can be up to 2 years of imprisonment or a fine, but the trial judge provided no substantial reasons for imposing the maximum sentence. Had the sentence been slightly shorter, the provisions of Section 8(3) of Representation of People's Act that provides for disqualification wouldn't have been applicable. Quoting from the order, the court observed, particularly when the offence was non-cognizable, bailable and compoundable, the least which was expected from the learned trial judge was to give reasons for imposing the maximum punishment. Though the learned appellate court and the High Court have spent voluminous pages in rejecting the applications, these aspects are not seen considered. Although the court acknowledged that Rahul Gandhi's comments were not in good taste, it refrained from discussing the merits of the case. A 3-judge bench comprising of Justices B.R. Gavai, P.S. Narasimha and Sanjay Kumar heard his appeal, challenging the Gujarat High Court's refusal to stay his conviction. To give a little context, let us rewind and look from the very beginning. The comment that led to this legal battle was made during a political rally in Karnataka in 2019, where Gandhi allegedly linked the Modi surname to thieves. Accusing Gandhi of defaming everyone with the Modi surname, BJP MLA and former Gujarat Minister Purnesh Modi filed a complaint under sections 499 and 500 of the Indian Penal Code over this alleged remark. After the Gujarat High Court lifted the trial stay, a Surat court convicted Gandhi, sentencing him to 2 years jail in March. Although the sentence was suspended, his conviction led to disqualification from the Lok Sabha as per Article 1021E and Section 8 of the Representation of People's Act 1951. This act specifically disqualifies a person convicted and sentenced to more than 2 years. Thereafter, Rahul Gandhi filed an appeal in a Surat City Sessions Court, accompanied by 2 applications seeking suspension of sentence and conviction. If he would have been granted a stay on conviction, his Lok Sabha membership could be reinstated. However, the Sessions Court dismissed his request for a stay on conviction, although he was allowed bail pending the appeal's resolution. After this, Rahul Gandhi challenged the Sessions Court decision and filed a criminal revision application. However, this attempt also faced a setback as a bench led by Justice Hemant Prachak declined interim relief and eventually dismissed the petition. The court emphasized that Gandhi, as a senior leader and representative of the oldest political party, had a responsibility to safeguard the dignity and reputation of identifiable groups, highlighting the case's impact on the Modi community. Moreover, the High Court stated that Gandhi's comment aimed at influencing election outcomes and utilized Prime Minister Narendra Modi's name for sensationalism. The court acknowledged 10 additional defamation complaints against Gandhi, including the one from Vinayak Savarkar's grandnephew in Pune over remarks made at Cambridge University. In the face of multiple legal setbacks, the Congress leader as a result appealed to the Supreme Court to challenge the Gujarat High Court's refusal to stay his conviction. He maintained his lack of malicious intent or intent to defame. Conversely, Purnesh Modi, the complainant, opposed the stay in an affidavit, asserting that Gandhi's statement defamed every Modi and particularly the Modwanik caste of Gujarat. He argued that Gandhi showed no remorse and claimed his actions displayed arrogance, insensitivity and contempt for the law. And Rahul Gandhi, in a later affidavit, responded, alleging that the complainant was exploiting the legal process and provisions of the Representation of People's Act to force an undeserved apology. Gandhi reiterated his innocence and questioned the sustainability of his conviction. Now that we are well aware of the entire factual background of the case, let us come over to the another important aspect, that is what exactly happened in the Supreme Court today. Senior advocate Dr. Abhishek Manu Singhvi presented arguments in defense of Mr. Rahul Gandhi. He began by pointing out that the original surname of the complainant, that is BJP MLA Purnesh Modi, is not actually Modi. He emphasized that out of the supposed 13 crore members of the Modi community, only a few BJP members have filed complaints of criminal defamation. Dr. Singhvi argued that this group of people with the Modi surname does not qualify as an identifiable class under Section 499 or 500 of the IPC. He also brought attention to the rarity of awarding the maximum 2-year sentence for criminal defamation, questioning the reasonableness. He stated, and I quote, "I am yet to see a non-cognizable, bailable and compoundable offence which is not against society, which is not kidnapping, rape and murder, in which the maximum sentence is given. How can this become an offence involving moral turpitude?" Senior advocate Dr. Singhvi further explained that this severe sentence would silence Gandhi for 8 years, disqualifying him from elections as per the Representation of People's Act. It was also brought to the attention of the court that there was no prior convictions, while there was a contempt case in the Supreme Court for which Gandhi has already apologized. Dr. Singhvi said, and I quote, "He is not a hardened criminal. There is no conviction in any case. There has to be some mutual respect in politics. I am not a criminal." The delay in the High Court's judgment was also highlighted during the arguments, stating that the order came 66 days after reserving the decision. He then discussed the consequences of the conviction, noting that it would necessitate a by-election in Wayanad constituency. "I have already lost 2 sessions of Lok Sabha. If the Supreme Court says no, I will lose the entire term," he expressed. Senior advocate Singhvi referred to the Prahari case, a 2018 judgment that held if the appellate court stays the conviction, it should also stay the disqualification. He also mentioned a Supreme Court order staying the conviction of Hardik Patel, a former Congress member now with BJP, in a criminal case. He raised doubts about the evidence as the complainant had not personally heard the speech but relied on a WhatsApp message and a newspaper article. Coming over to the arguments presented on behalf of the complainant, Senior Advocate Mahesh Jethmalani presented his arguments, highlighting that videos of Rahul Gandhi's speech were submitted as evidence along with a witness who confirmed its contents. The speech, where Gandhi mentioned various Modi names linked to controversies, was never denied. Senior Advocate Mr. Jethmalani quoted Gandhi's speech. "अच्छा, एक छोटा सा सवाल, इन सब चोरों का नाम मोदी 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 कैसे है? ललित मोदी, नीरव मोदी, और थोड़ा ढूंढोगे तो और सारे मोदी निकल आएंगे." He argued that Gandhi's intention was to defame the entire Modi community due to the Prime Minister's surname. Gandhi claimed to not remember the speech in his trial court statement, to which Justice Gawai suggested that could be due to the frequent public addresses made by the politicians. Referring to a Supreme Court precedent, the complainant contended that Modi constituted an identifiable class, allowing any person with the surname to file a complaint. Mr. Jethmalani further argued that the Representation of People's Act does not mention moral turpitude, but disqualification on a 2-year sentence. He referred to 2013 Lily Thomas case, where a struck-down provision for pending appeal disqualification was being indirectly reintroduced. All in all, the complainant argued that a history of rash speeches disqualifies Gandhi from seeking concessions. He also highlighted Gandhi's lack of contrition. Another important thing to note is that while hearing the matter, Justice Gawai questioned if unrepresented constituencies mattered, and also highlighted the lack of reasons for maximum sentence awarded. He noted that the impact on both an individual and their entire constituency. Well, as of today, the Supreme Court's 3-judge bench has granted a stay on the conviction of Rahul Gandhi, and with the stay on his conviction, the Congress leader's disqualification also remains in abeyance. This was all for this video today. While concluding, I want to mention that there are a lot of other details on this case. So if you want to read a more detailed report, then you can click on the link provided in the description box below, or you can also visit our website www.livelaw.in. Thank you.